Yes, yes.
Nivedita Acharya. I'll be the court officer for this
Yes.
particular round. And
Hi.
this is
Okay, thank you.
Your Ladyship, may I draw your attention? This is the memorial for both the teams. This is for the applicant side and this is for the respondent side. Your Ladyship, we are also having the statements of facts and also the clarifications as well for
Okay.
your more reference into this particular case. Your Ladyship, this is the score sheet that we have.
Okay.
And for your reference, this is the marks distribution evolution criteria that you have to follow, your Ladyship. And this is for more your reference, this is how we are supposed to give them the marks. Yes, your Ladyship. And Ladyship, I'll request you a little thing if you
Yeah.
can do it. Ladyship, if you kindly use pencil while marking,
Giving the marks.
marks,
Okay.
it will be
Easier. You have rubber.
easy. Absolutely, your Ladyship.
Okay.
Everything is there.
So this
Yes.
is the
This is the
maximum.
Maximum.
Uh,
Your Ladyship, let me explain to you. For
so
both the
which is the
speakers-
main sheet is which one?
Yes.
This is the main
this is the
sheet?
score sheet, Your Ladyship. These two are the score sheet
Right.
for the respondent and for the applicant.
Okay.
This is the applicant one. Your Ladyship,
So on
for
20 we will be
20,
marking. Speaker
20
one,
this,
speaker
20
two.
that.
Yeah.
Right? Thank you, Your Ladyship.
And your ladyship, we are giving a bell, warning bell, when 5 minutes remaining, 3 minutes
Yeah.
remaining, and time's up.
Okay, Ladyship. For any further assistance, Ladyship, I will be
Yeah,
just
yeah.
there. You just need
Thanks,
to call
thank
me up. Thank you so much, Ladyship.
হ্যাঁ দেখে নিচ্ছি এই
টিন
দুটো
কোড আছে
হ্যাঁ ওয়ান স্পিকার টু
হ্যাঁ টিন কোড দেখে দেখে
Kindly have your attention, please. This is the compendium for the applicant side. They will be referring to this particular compendium, and this is the compendium for the respondent side.
Yes. Yes, yes.
A very good afternoon, everybody. We have now come to the finale of the late Honorable Justice M. Fatima Bibi Memorial Moot Court Competition 2026, organized by the Moot Court Society of the Department of Law at Sister Nivedita University. May I begin by requesting our Pro-Chancellor and Vice-Chancellor, sir, to kindly come forward to felicitate the judges of the final round of the competition. Permission. With your permission, may I request our Pro-Chancellor, Pro-Vice-Chancellor to please. We request our Pro-Chancellor, sir, to felicitate Honorable Justice Shampa Sarkar. May I now request our Honorable Vice-Chancellor, sir, to felicitate Honorable Justice Tirthankar Ghosh. I now request our Honorable Pro-VC academics to kindly come forward and felicitate Professor Shobhik Roy, Associate Professor, West Bengal National University of Juridical Sciences. Oh, Professor Shobhik Guho. Thank you, Honorable Pro-Chancellor, Pro-Vice-Chancellor Academics, and our Vice-Chancellor, sir. With the permission of the bench, we now proceed to the final round of the competition.
Check. The council is here appearing on the behalf of the appellates, which is the Bhaskara Singh and Cosmopolis Company. Much obliged, my lords. The council seeks permission to address the bench with the statement of facts. Much obliged. In brief, my lords, this case is arising out of a contractual obligation which was done within the scope of the appellates and the respondents. This contract was of a promotional kind contract or a commercial contract for which the respondents were of the duty to perform the contract for the promotion of a chic brush cream, which is the product of the Cosmopolis company. The respondents here is a virtual influencer, which was not at all aware for us. We were not aware of the fact that they were the virtual influencers. We were of the opinion and we were of the intent that there is an influencer, and the statement of fact says so, that we were of the opinion that the respondents were a natural human being, and therefore we, because of the highly influential nature of their Instagram account, we went into a contract. This particular message was approached on 23rd January via the Instagram, where we have received the reply stating that the manager should be contracted. On email account, the same was accepted on 24th of January, on 25th of January. After that, the first reel for which we paid 1 lakh rupees were released, and with the comments of certain people on that reel, we came to know that this particular persona is an artificial intelligence generated persona, and therefore it's not a real human being. Considering the same, we immediately frustrated the contract, and therefore we are of the opinion to not give the rest of the 1 lakh rupees or 50,000 rupees for the other 2 posts which they already released. For the same, the respondents approached the district court on 21st of March 2026. The district court decreed in their favor, and therefore this appeal under section 96 of CPC is here within the scope of this honorable bench. Much obliged. Milords, if the Milords picturegram, Milords, if the bench gives permission, the council will directly proceed to the arguments. Lords, the council 1 will be dealing with issue number 1 and 2 for 15 minutes, and my co-learned counsel for appellates, council 2, will be appearing for issue number 3 and 4 respectively for next 15 minutes. Issue 1 at hand stands as whether a AI-based persona can be monetized, and non-disclosure of this AI label amounts to the deficit in the public trust doctrine or not. Your ladyships and milords. This submission will be a threefold proposition that A, the confident party did an active concealment of the fact. B, the active concealment of the fact was very much deliberate on their part. C, it amounts to fraud under the ambit of section 17 of Indian Contract Act, and therefore the public trust, which is still in a developing jurisprudence in the ambit of this particular country. Milords, coming to the submission number 1, section 17 of Indian Contract Act, it says that mere silence as to a fact is not a fraud. And then if I take my lord's attention to section 17 of Indian Contract Act, I'll read it for my lords. It says that the contract nevertheless is not voidable. And therefore, section 17 goes again and says, unless the circumstances of the case are such that regard being had to them, it is duty of the person keeping the silence to speak. Therefore, my lords, A, when we were entering into the contract, it was on their part to tell us that yes, we are an AI-based persona, and it was on our part to check the due diligence, which we deliberately did. My lords, I would like to take the bench's attention on compendium which has been submitted. Six pages of this Instagram post, my lords. These are the virtual influencers, other than Nisha Batani. And every single virtual influencer here says AI label. The next also says AI content. The others also say AI content. And all of these influencers who are the digital or AI generated influencers on Instagram, they deliberately say that the disclosure of AI information is must. And if we see the Moot proposition, my lords, page number 9. Page number 9 of Moot proposition gives the post of Nisha Batani. There is no AI content label over here. Therefore, it is a deliberate non-disclosure on their part of an active concealment of a material fact. And therefore, I bring the attention to the consumer protection guidelines, which have been given within the scope of the country. Clause 14 of these guidelines says disclosure of material fact. I'll read it for my lords. Where there exists a connection between the endorser and a trader. There was a connection because we were entering into a contract. Or advertiser or endorsed product that might materially affect the value or credibility of the endorsement, and connection is not reasonably expected by the audience, such connection shall fully be disclosed in making of the endorsement.
Counsel, you are reading to us the consumer protection guidelines. Are you contending that your client is a consumer in this particular case?
No. Because Section 2, Clause 28 of Consumer Protection Act says that commercial use is not a consumer. But we are here of the opinion about the disclosure. And moreover, my lords, I'll take your attention to the... Your ladyship. Your ladyship. Your ladyship. Your ladyships, because there was not even an existing, I'll come to the issue number 2, which is dealing with the copyright. There was no copyright on their part. And the copyright cannot exist on something. We will come to the issue number 2 where we are talking about the copyright. Since they do not have any standing copyright, we are not subject to corrections of this particular bench. We are not on the obligation to not change the sari color and use it on the other banners. We are not stating the fact that it is irrelevant to our consumers. We gained the sufficient amount of attention from their fact. We are not saying that our product is giving a bad impression on the consumers. It was giving a good impression. And therefore, if they can generate it on their part, we also change the sari color and use it on our brands because of non-subsisting of a copyright on the same. Your ladyship, if that answers your question. Much obliged. Coming back to your lordship's concern, this is the meta guidelines, Instagram guidelines, your lordship. It will be, in the compendium, it will be the Instagram AI information guidelines. As updated on, I'll emphasize on this, Picchagram guidelines, because it is mutatis mutandis applies to Instagram. Here in the Moot provision is Picchagram. As updated on 1st July 2024, the emphasis is supplied on this. We begin adding AI information labeled to a wider range of video, audio, image, content when we detect standard AI image detectors or when person disclose that they are uploading AI generated content. This is the Instagram or Picchagram guidelines is stating. Now Instagram on 2024, July 1st, they are stating that the person must disclose it. And what they have done is, they have not disclosed to Instagram or Picchagram, they have not disclosed to us also. Moreover, the last guidelines, because this is not perhaps the consumer part, the guidelines, the ASIC guidelines, and this is not the draft guidelines because there are 3 guidelines. This is not the draft one, this is the actual guidelines which we are emphasizing on. Clause 3.4 of this particular guidelines in the compendium.
Counsel, before you proceed to clause 3.4, I have a question. You are referring to Instagram guidelines here. You are not representing Instagram, from what I understand.
We are not.
So, under these guidelines, the respondent is certainly beholden to Instagram if they are using Instagram services. How are they beholden to your client via the Instagram guidelines in terms of disclosure?
The only prima facie what we would like to stay after stating this Instagram guidelines, that they are not even disclosing the guidelines to Instagram and not to us.
But once again, counsel, the guidelines, the Instagram guidelines do not beholden the respondent to your client. If you are talking about a point of law, then you can say that by law, the respondent is supposed to be beholden to your client.
That is what, when we come to section 17 and there is an active concealment, the fact comes that there is a duty to speak. Now this duty to speak arises out of some legal obligation or out of some ethical observation or out of some moral obligation. 3 things. Now, when they are, I am telling you that they are at the very first place. It was their duty to acknowledge the material fact and disclose it to us, because it's on our part as doctrine of caveat emptor. What we have done is we have checked all the other accounts. We are of the opinion that all other Instagram accounts were having the AI label, and we were of the opinion that these Instagram labels are.
Is that an exhaustive search that you have done? Every single Instagram account with digital avatar has an AI label, or is this a sample?
Inexhaustive research, my lords. Definitely inexhaustive research, but that does not contend that majority of them are wrong. The only contention is that when majority is doing the same thing, it's not on our ordinary diligence, or because if my co-learned counsel will be dealing with the section 18 misrepresentation also under the contractual obligations. The ordinary diligence is something which we need to put forward. We have done the due diligence itself. Now, coming back to
Proceed.
the Milords. 1.4 of this guidelines, and perhaps you note the draft guidelines, your Lordship, Milords. It says, and I read it for the bench, a virtual influencer must additionally disclose to the consumers that they are not interacting with a real human being. The disclosure must be upfront and prominent. This is the guidelines. Now, again, the question may arise that we are not consumers. For the contractual obligations, we are the consumers, because contract is on our basis between us and them, and therefore they must have deliberately said it to us that okay, we are the AI generated, we are using the AI generated persona for your publication, and that is the active fact, and we must before and tell it to you. This is the submission number 1, Milords. Submission number 2, Milords, coming to again the public trust part. I would like to take the bench attention to the Tata case, which is mentioned in the compendium. Commercial speech, in this particular case, in the ratio itself, was stated as a fundamental right under Article 19, Clause 1. And if someone is doing a fraud, then they are deliberately avoiding it under Article 19, Clause 2. Now, my lords, what they are doing is, the court said, and I'll read it for my lords. The principal answer that the law requires reasonable diligence. It's not permit a party who deliberately creates a misleading commercial impression to benefit merely because the other party did not independently uncover the deception. We have already stated that we have done the ordinary diligence. We have stated that we done beyond that due diligence. We have read the guidelines, they are not disclosing it. And the court now says that commercial speech is a part of Article 19. And if independently they are knowing, they are in active confidence, they cannot conceal it. Thirdly, my lords, this particular public trust jurisprudence, starting from the Hamdard Dawakhana case, coming to the next case, that is the Tata level case, and lastly, in Indian Medical Association, the doctrine is still developing, your leaderships, that whenever a public is in confidence of a product, ours is a cosmetic product, public always, and we also did the same. We are of the opinion that he or she Danisha Betani, is an active participant, an active influencer, and not a digital one. Why we chose them? Because we were of the opinion that they are not ordinary on their part. They are extraordinary. They gained 50,000 followers. We are a cosmetic company. Consumers who are using will be taking the account of this particular influencer and coming to this of the decision to buy it. And therefore, we were of the opinion that he or she must be a natural human being. Now, what they have done is they have deliberately, they will at the end deliberately mislead our consumers as well. Therefore, now I'd like to bring the attention to the foreign jurisprudence case, which is because we are in still developing stage, that is Lord versus Taylor. In this particular case, it was saying that representing an endorser as an independent user or an ordinary customer, point number 1. 2, failing to disclose a material collection. And 3, presenting paid commercial advertisement as a statement of opinion of the individual subjective source. Now this opinion of this individual who is the influencer matters to us, and an AI cannot have an opinion at the very first place, and therefore it will at the end mislead our consumers. This is what we do with respect to the public trust doctrine and with respect to the non-disclosure of the identity. My lords, if the bench gives permission, we'll directly proceed to issue number 2.
Just one. Anyhow, Council, just one question. If you can refer to, page 17 of your memo.
Yes.
Herein you are arguing that a virtual influencer must additionally disclose to consumers that they are not interacting with a real human being, and such disclosure must be upfront and prominent, not buried in a bio, a hashtag or a comment thread. And you have cited the 2026 update for ACI guidelines as supporting authority for your argument.
Milords.
Council, the 2026 update, is it retrospectively applicable?
Milords, this case is also of 2026.
But Council, the 2026 update that you are talking about has come into picture in May 2026 and it has been notified in June 2026.
That's
all the facts of your case scenario has happened before that.
no. Because therefore, we mentioned 3 guidelines, Milords. This is the last one.
The last one is the one which you are referring to, insofar as your.
No. The very first we referred to this Instagram guidelines.
But Instagram guidelines is not law, Council. There is a difference.
Milords, guidelines, ACIC guidelines are also not laws, Milords. With subject to your correction, Milords. And none of the guidelines are not laws and they are not legally binding. We agree to this. But there were previous guidelines as well. These guidelines, because of the regulatory nature of AI, the ASIC keeps on updating them.
Absolutely.
And in March.
And the regulation and the specific regulation that you are spending here citing has been updated in 2026 May.
The last update. Not the first and last update.
The last update is what specifically talks about the prohibition that or the disclosure
Milords,
that you're talking
because the idea behind it is because we are stating Instagram guidelines of 2024 and then this guideline is of March 2026. Additionally, therefore, very specifically we have mentioned additionally. That was not deliberate on our part when we are writing additionally in the memorial itself. Because of the fact because this court is going to create a wonderful jurisprudence on this part. And therefore, we are actually referring to the guidelines which came afterwards so that the court comes to the conclusion and creates a jurisprudence accordingly that what the external world is suggesting us.
So, Council, you essentially are expecting the court not to decide the matter in favor of your client, but to create an exceptional jurisprudence. Okay, point noted.
No, Milords, we again are not of the opinion that we should be the single-handedly be beneficiary of this particular case. No, because again, this is also deliberate on our part. If you go and read Milords, the Moot proposition, they have been into previous collaboration with n number of brands. If they must have not disclosed to us, again, it's a claim and a presumption that what is the criteria, what is the claim that they must have endorsed to the previous collaborations as well. And therefore, we are not saying that we are the only stakeholders. Though we are the only parties, the parties is Vaskara Singh and Cosmopolis, but they have already been into previous collaborations. And therefore, if this particular case court makes an exceptional jurisprudence, that will be beneficiary for external world as well. Obviously, this is not restricted to merely to us, Milords. Much obliged. Coming to issue number 2, Milords. Issue number 2 deals with whether AI generated images can be copyrightable or not. Very first part, it is very clear under the ambit of copyright in India that what are the criteria of a thing to be copyrightable. Coming to the DB Modak versus EBC case, which is the exact jurisprudence on which India, this particular in Barcelona, mutatis to India is working upon, that A, there should be a skill, B, there should be a judgment, and C, there should be a minimum modicum of creativity. That is what the settled jurisprudence of copyright in India is. Now, Milords, what we are saying is we are not defending to the fact that they are meticulously giving the prompts, but they are meticulously giving prompts to what? Agentic AI. An agentic AI is always trained on a non-local data set, a local data set, and machine learning models. Therefore, the Chat Jenny, which is mutated is the Chat GPT in this our case, is a self-learning model. The moment they are giving prompts, they must be satisfying the criteria of skill, they must be satisfying the criteria of judgment, and they must be satisfying the criteria of modicum of creativity as well. But at what cost? The cost is that a pre-trained AI model is definitely interfering in between, and from where I am coming from, I'll take your attention, Milords, to the Moot proposition number, page number and 10, 11, 12 and 13. what they have mentioned in the Moot preposition is that he is meticulously giving the facial expressions done. We are not defending to this. Body alignments, yes, we are not defending to this. Can we see that there is a background in this image? They're not giving it. In the next image also, the background, they're not giving it. The light and fraction, they are not giving it. And moreover, lastly, because the reel which they have created contains an audio. That for an audio to be created, the copyright must goes to the producer, and they have done a cinematography work as well, and therefore,
All right.
and what they have done is they have created a video. That video contains an audio, a persona, and lastly, it contains a cinematography work. At what cost in the Moot preposition they are saying that they are giving the prompts for audio as well? Nowhere. They are giving the prompts for cinematography as well? Nowhere. And therefore, I come from the fact that there is a substantial amount of intervention on the part of the agentic AI, which is ChatGenai AI in this particular case, because that audio is generated by ChatGenai. That cinematographic work is generated by that background, texture, context is also generated by the ChatGenai AI.
No, but can you deny the fact that the similar prompts could have generated a different result altogether unless he had used his special skill to design the face, the body, the structure, the features? Those are specifically designed according to the prompts which has been given. Aren't those his captive outputs?
Milord, this is what we have experimented. We changed the sari color without changing any single facial feature of Nisha Batani. We changed the sari color, we changed the background as well. Therefore, that is not a skill. We never hired an engineer. This is what our social media team itself did.
Are you saying that the skill, for the purpose of having a skill or exercising a skill, person needs to have a specific degree?
Yes, Milord, we are not saying that. If you are using a skill, if you are using a judgment, along with that sweat of the borough doctrine and CCH Canadian case that we are jurisprudence is developing for, there should be a minimum modicum of creativity. Now,
Creativity does not depend on the person's identity.
no, that definitely does not apply to.
Your argument that your digital media team or design team,
My ladyship asked that whether that particular skill of prompt writing is not a skill on their part. And we are saying that our team also wrote these similar prompts. And therefore, that is not an exceptionally good skill on their part.
By giving your exceptional prompts, all that you managed was change the sari to your cream, the packaging of your cream. The other features of Nisha was not changed. So the question is that how can you say that there is no skill or industry involved? Because the prompts given by him could have also generated some other kind of an image and not Nisha. So to get Nisha as a synthetic persona, he had to use the prompts in a particular way and design it in a particular way. So does not that involve skill or artistry?
My ladyship, if you recall my very first question, I never contended that they don't have any skill. We are contending to a fact that they use their skill, they use their judgment. The contention is all about, your ladyship, the modicum of creativity. Now, if you go and see this particular image on our product, article, the facial features are intact on our part, which means the prompt which our team gave was of such nature that it was able to generate a similar facial expression and then also changing the sari color and therefore creating a same identical image of that particular AI character. That is what we are saying, my lords and your lordships.
Okay.
Coming to the next part, your lordships.
Here are you in page 12 of your memo, when you are citing section 2D subclause 6, you are referring to a person who causes a computer generated work to be created. Does your submission include any distinction between computer generated and computer assisted work?
No, my lords, I was about to come to the very specific part, because who can be author of this particular computer generated things? The section 2, subsection D and clause 6 of the Copyright Act says that a person who causes to generate shall be the author. Now what they are doing is they are taking this as a sole hand rule. This is not a rule. Rule says that it should be read with section 13 of the Copyright Act. And section 13 of the Copyright Act says that there should be, again, referring to the EBC DB Modak judgment, that what can be copyrighted, that the work should be having a skill, the work should be having a judgment, and therefore the modicum of creativity. What they are doing is they might come up with a argument that we are generating this particular images with the help of a computer. But Milord, now the fact of legislative intent comes in picture. This Copyright Act, when this definition of computer generated program and computer authorship has been given, was AI in picture? No, my lords. Now what we are saying is, computer cannot think, a genetic AI can. Computer, what we are saying is, computer generated thing is that, for example, we are using a Photoshop to edit a picture. We are giving all our labor, all our skills, all our judgment to the particular Photoshop, and therefore that Photoshop has nothing to do and nothing to contain with our editing. And therefore that particular computer generated thing will be under the ambit of section 2 clause D and subclause 6 of this particular Copyright Act. But whether the last part wherein the computer is thinking, ChatGPT is a self-learning model. It can deliberately infringe the particular prompt according to his or her previous training, its previous trainings, and therefore that particular program, computer program, cannot be incorporated under the sense that the computer program, AI-generated computer picture can be taken into the definition of computer program-generated work.
All right.
And for that particular thing, I would like to, we have a specific case, Your Honor. The case says, Milords, much obliged.
Much obliged, Milords. The council seeks permission to address the bench as Milords and individually your ladyship and Milords.
Yes.
Much obliged. Milords, am I audible?
Yes,
yeah,
yes.
Yeah, thank you. Milords, firstly, it's a pleasure to sit to argue in front of this bench. Secondly, Milords, the issue, finally, issue 3 and issue 4, which I am dealing it. Firstly, I will just like to throw some light on where we are at currently. So we have argued issue 1, issue 2, which deals with copyright and public trust. Secondly, what we have done is we have argued whether 2D6, with respect to human inputs, whether Balwinder, the other party, has copyright on it or not. So the only standing judgment is EBC versus DB Modak, which says the sweat of the brow doctrine. Along with that, something extra must be added. Now, Milords, let me take the premise to today's day and age. Mobile phone is accessible to everybody. And ChatGPT apps, pari materia to ChatGenie AI, is accessible to most people. So now, is giving a prompt something extra which was presented in the DBC versus EB Modak case? Because with the revolution, the mobile revolution in India, it is no longer something which requires that kind of extra which came, as my co-learned counsel said, from the CCH case and so on, that something extra was needed. So we are contending that, yes, 2D6, he has given inputs, right? If you have question.
No, counsel, I just wanted to figure out if a ChatGPT access is given to you, will you be able to come up with a prompt that will produce a picture identical to Nisha Batani's virtual avatar?
Milords, to answer that, what if I write to ChatGPT, please keep on creating a prompt which creates the best image which can be marketed to 1,000 people? Because they are self-generating in nature.
It will still not produce Nisha Batani's picture. It
Milord,
will produce something
Milords,
else.
It's correct. Now, what we can see, Milords, is if we go to the facts of the case, we went to them. Why did we go to them? Because they were a popular account, right? 52,000 plus posts and so on and so forth. So now we went to them because they had created something which was marketable. The contention lies. Now what you are asking, what the contention lies is, whether they use that skill. At that time we were unaware of the question that whether it was a AI or a real human. And that is in page 2 of the Moot proposition, where it has been stated that the expectation from our side was that we were dealing with a real life influencer.
How come, counsel, you yourself are saying that you had gone to them only because of their nature
yes.
of popularity
Yes.
and their marketability?
Yes.
Neither of which depends upon whether it's an individual or a virtual avatar.
Yes, now I will
That's a
come
bit of
to
a self-contradiction.
absolutely. But when we put it in a contractual obligation, what happens? Section 10 applies.
No.
Section 10 applies, Section 13
Contractual
applies.
obligation is a separate thing, counsel. You are arguing initially about the DB Modak's requirement.
Yes.
From where the question was,
yes.
you claimed that there is the prompt is nothing extra.
Yes.
So in relation to that,
Yes.
you went to saying that this is not a virtual avatar. But the point is that if 5 people on random
Yes.
asked to come up with a prompt,
Yes.
do not come up with an equally accepting output,
Yes.
then clearly prompt is separate. And you yourself dodge the question as to whether you will be able to create such a prompt, which clearly shows that not everybody can.
1 second, we created the same prompt. We just changed the color
Not
of the
you,
sun.
counsel. Your
Our
digital
team. Yes.
Precisely.
Now, Milord, if you could just give me a moment. We created the prompt and our sales rose not because of the first reel. Because if we read the Moot prop very clearly, the sales arose when we got the most viral image. And then what happened? We changed the color of the sari, we made changes, your ladyship. And finally what happened was that packaging drove our sales, which we can draw correlation, which they will come up to at some point of time. So now if I could move on to issue 3, which basically deals with consensus ad item. So now our contention was basically that we were a cosmetic brand which is to be applied on people. So it requires a human to human connect. So now so we wanted somebody who was a real life influencer. So now if there is no meeting of the minds, it is basically agreeing to the same point in the same sense. So if there is no meeting of the minds, firstly this contract itself is on very dicey situation. So because as we know, and then what happened was the consent also that was got upon the fact that we thought that they were something else, but they turned out to be something else. So now you can always come to the point that why wasn't it specified in the terms of the contract and so on and so forth. But because the case has arrived at this point of time, it is very difficult for me to justify it, but it will be claim versus claim again because the facts are silent on it. So now Section 10 tells us that consensus ad item was not reached, which is hitting at the heart of the contract. Now what is happening is there is active concealment of their part. This is not mere disclosure. Now why do I say so? Because if it is, how did we find out that they were an AI avatar? We found out by giving money to a third party company which went ahead and which found out that it is an AI avatar. And 1 lakh rupees payment was already done. After that, what happened was there were 5,000 comments, your ladyship. There were 5,000 comments which came and somebody commented digital AI avatar. So now it rang bells upon us that this may be a digital AI. So what happened was we contacted a third party. So that is where I want to draw the distinction between due diligence and ordinary diligence. Ordinary diligence is something which can be found out with not much effort. But here, to find out, we had to follow due diligence process, which we were not thinking that we had to do. So the Section 19 exception that they can use for misrepresentation and fraud, it goes out of the picture. So now, if I come, now what has happened is we have a contract for 1 Instagram post and 2 reels. So the first Instagram, 1 reel and 2 pictogram posts. I'm very, very deeply sorry. So now what happened is that pictogram post, 1 lakh rupees we got, and the next to this thing we vitiated. Why did we vitiate the contract? Because they were acting on fraud. So basically we should get reparations under 51 to 54 of the Contract Act, and furthermore the performance was not in their side also, not on our side also. So basically we have quoted cases of Moinuddin, Abraham, George, which deals with and traders and other cases. So now I want to take Milords to my compendium, page number 6. Compendium, the second compendium, page number 6, page number 5, Milords. Yes. So basically, it is a case of Avitel Post Studios versus HSBC PI. So what happens is, Avitel is a company which there is a rumor spread in the market that something has happened and it is going to convert BBC's old heritage films to 3D films. So now what happens, Milords, is HSBC PI, which is a private venture, what it does is it pumps $60 million into the company, the Avitel Post, this thing. So here what I am coming to is the material fact, the materialness, that here HSBC PI invested $60 million based on the fact that Avitel was supposed to get a BBC contract, but it did not get a contract. So the Supreme Court held that the fraud that has been done and the contract is voidable. So under section 17, there was a fraud done because the material fact which induced payment to be done was not done. The material fact was itself a false fact. So now this is my case with respect to this fraud. So now further, what the strongest case they can present is MS Shrish Dhawan versus Shaw Brothers, which basically says that silence or non-disclosure of facts not required by law to be disclosed does not amount to misrepresentation. But that judgment goes further to say, that it's in page number 8 of my compendium. That judgment goes further to say that it does not amount to fraud where the circumstances are such that silence is equivalent to speech, or where there is a duty to speak because the fact is likely to affect the willingness of the other party, then the fraud may still be established. Yes, Milord.
Is it your contention that
Yes.
had your client been aware of the fact that this is a virtual avatar and not
Yes.
a real life person,
Yes.
you would not have proceeded with the contract?
That could be one of the things. The other thing would be, if it was there, then we would have at least added some kind of a disclaimer. Because
What is
we
the
are
prejudice caused to you by this fraud?
the prejudice, if we talk about monetary, this thing,
You
there
have
is,
gained.
yes, the payment that we had done, it was all based on a false premise. We have to also remember we are standing in front of court of equity. It has the
It's an appeal court.
yes,
Not court
it's
of
an appeal court.
Not court of
Okay, so subject to your correction, my ladyship. So even if that is taken, unjust enrichment has happened on their parts, which is my fourth issue.
How is it unjust enrichment, counsel? You yourself are claiming that you have profited post this contract.
Unjust enrichment comes exactly how I come to that is, they will argue that we have done unjust enrichment. But for unjust enrichment, first you have to think of something. According to our submission, it may subject to your lordship's correction, they do not own the copyright of Nisha AI Avatar, the chatbot. There is no copyright.
No, but counsel, my original question
Yes.
was that had this knowledge of its digital nature been known to you,
Yes.
something which you were saying
Yes,
that they have actively
yes,
concealed,
yes.
would your client have gone ahead with the contract or not?
They may, there are conjectures I cannot do in front of the bench.
You don't
But in
have to,
all-
especially because of the fact that at which date did your due diligence reveal that this is a digital avatar?
After the 1 lakh had been paid.
What is the date, counsel?
2006 to 2026. The date is 3rd February 2026. Yes.
And after that, what was your client's reaction to this knowledge?
The client reaction is not specified in the Moot prop, the specifically. But yes, I understand, my lord, where you're. I will duly try to defend. So the thing is that what we do is, we realize, because we are a for-profit company, so what has been done is, once we realized that the copyright was not there, so we used it to our benefit. But
So the contract which you were saying was voidable from your side because of misrepresentation
Yes,
from an
yes.
active concealment.
Yes.
You essentially used that contract to make a profit for your client.
the thing that we need to understand here is the profitability and where do we come from? We are Cosmopolis. Cosmopolis Vaskara, the concern that we are setting up we are not a very large brand. We are a very modest brand which has an image. Now, my lords, just one submission I would like to make. When the premise began, we were frauded according to us, right? So now something went on. So now, if we go ahead and we do a disclaimer that all of this is AI generated and this and that, which we will, in fact. But if we do that, what happens to our brand identity? A small company which runs on debt, we also have to realize the monetary aspect.
After knowing that it is an AI generated image,
Yes.
you pursued it, you only changed the sari to your packaging, cream packaging, the carton
Yes,
or
my
whatever,
lord. Yes.
and you earn lakhs and lakhs of money. And then you said, we will not pay you because this entire transaction was fraudulent.
Just one submission I want to make. Is it in all probability that whatever sales has been done, can it be just related to the sari change that we have done? Is this the only reason why the product was sold? This is the question.
Yeah, you can't ask that question.
This is not the question.
That's probably a question you should ask your client.
This is a humble submission that there is no fact in the proposition that
you change your stand after you profited. You change your stand. You could have changed whole of the advertisement.
Yes.
You did not do that, sir.
Yes, ma'am.
What you have done is that you have retained the structure and
Yes.
only changed the salary. But you have stuck to that advertisement. You have not thrown away that advertisement and gone in for a second one.
Milords, the only question that the only submission, humble submission that I have is, was there a legal duty for me to change the to do all the changes? Was there a legal duty before me? Morally, ethically, yes, there have been.
The legal duty is not of yours. The issue is that their non-disclosure that Nisha is an AI generated image.
Yes.
How has it affected you? For you to withhold payment, make profit, use Nisha as your brand ambassador, even after knowing that it is a synthetic persona, and then withhold the payment and say the fraud vitiates also, I will not pay, and they have no case against me.
Milords, there are two distinct questions. First, when the contract was settled, it was on one Instagram reel and 2 posts. That is with respect to the contract. The other thing that happened was this packaging and selling, there is nothing like contractual in nature which has been done. We have not gone into any kind of contract with the other party, Balwinder. This could have been any image that we have used.
But why are you then relying on section 17?
Milords, section 17 is with the first part, where the actual contract was done for 1 post and 2 reels, on the pretext of which the evidence that they were given is at the impersonation they have done. My manager Balwinder, if Lords could kindly go to
There
page.
is no impersonation here, because Nisha is not impersonating any other human being or human figure. She is a synthetically created persona by a person who claims to have exercised his skill and industry to create that personality.
If you, my lady, if I could read out page number proposition page number 13,
Yes,
where the
yes.
chats are there
Okay.
of Picturegram, there you can, there one can really, I humbly submit that the information is visible. Hello, Mr. Nisha, this is sent by us. Then what had they reply? That sounds interesting. For further discussion, kindly share a formal proposal with my manager Balwinder at this email.com, and my manager will review it accordingly. So here we have direct corroborative evidence where they have done this fraud. Then absolutely you are welcome. Looking forward to reviewing your proposal. Have a great day. So they have directly used that. Please, this is my manager. This is
Counsel,
Yes.
who signed the contract on their behalf?
Balwinder signed the contract because he's the manager. He may have this.
And who did
power.
you pay to? How were the payments made?
We made it to Balwinder Mukherjee.
Then-
As so
Counsel, ordinary diligence would have at least required you to see some kind of evidence that Balwinder had the authority to enter into such a contract on Nisha's behalf. That's not part of due diligence, by the way.
Milords, now the transaction is not a part of this deliberation which I have, for the issues which have been.
Arguing vitiation of a contract.
Yes.
I'm just simply telling you are arguing misrepresentation. You are the one who says meeting of minds is not there. I'm
Yes.
just trying to figure out where this meeting of minds was not there at which point of time.
Meeting of minds was not there at this point of time. They presented, this correspondence happened. Yes, you have question.
Okay.
First,
Fine, proceed. I think you can proceed
Yes.
with the next issue, that last remaining.
Yes, yes. Milords, I would now like to go to unjust enrichment and the copyright act.
Yes.
So unjust enrichment, I would like to, because my lords are very aware and everything. So I'd like to go to the compendium page number 35, which directly deals with the case of Accurate Internet Services versus Star India, where a similar experience occurred. What happened was BCCI organizes the cricket matches, so everything was the Star India was given every kind of digital rights and also the copyright. So Star India, what it did was there were 3 companies which started selling match updates, live scores with respect to cricket scores and all. So now what happened was Star India went against them because they told that it is our copyright, you can't sell match data to people for a amount of money. So now what happened was that the court came to this conclusion, page number 37, point number 2, where it says that if it does not have a copyright, because it is very essential, match data cannot be monopolized over, and other things were also deliberated. I just picked this up. So if it cannot claim copyright, then on the basis of that, unjust enrichment can also not be claimed with respect to copyright this act, and which section 16 says the copyright subsists in this act. So finally, I would like my lords to take to the judgment, to my memorial, that if the allegation against us is that we came with unclean hands, they also came with unclean hands. It is not just that we came with unclean hands and they came with clean hands. It's so.
Yes, let him continue.
Yes, my lords. Much obliged, my lords. So basically, enrichment, what we are saying is that the increase in the sale of sari was not only due to that image, it is also with our brand loyalty, and other extra factors are also related to that. So there is nothing to think about that. Only because of that packaging and selling of that product, the sari, we got a lot of sales. Secondly, our point is that at the claimant's expense, now Balwinder voluntarily published an image on the platform. He retained no exclusivity. This is what we are arguing. Thirdly, inequitable retention. Balwinder, the 1 lakh that we gave, it was basically derived out of very, very wrongful practice on their part. So this also we should get. And now finally, I could take Milords to section 55, which talks about copyright and how the damages can be done. But Milords are well aware with this, so I will move to the prayers. So basically, in the prayers, what I would like to say is, wherefore, in the light of the facts and submissions advanced, the appellants most respectfully pray that this honorable court may be pleased to allow the present appeal and set aside the judgment dated 21st March 2026. Hold that the AI generated works in question do not confer enforceable copyrights on the respondent. Hold that respondent's alleged non-disclosure regarding AI generated nature of Disha Bhattani vitiated the contractual arrangement. Set aside the finding of unjust enrichment against the appellants. Grant an interim injunction under Order 39 Rules 1 and 2 of CPC. Pass any such other orders as this honorable court may find fit and proper in the interest of justice. And for this act of kindness, the appellants, as in duty bound, shall ever pray. All of which is respectfully submitted.
Thank you.
Much obliged, Milords. It was really very encouraging. Thank you.
council would like to adhere to the timeline of 15 minutes pertaining to her issue number 1 and 2. Issue number 3 and 4 will be dealt subsequently by my co-counsel for 15 minutes again. The council here presenting Balvinder as her client. With the permission of the honorable bench, the council would like to address the bench as your lordship and ladyship individually and my lord collectively. May I? Much obliged. If my lords are well versed with the facts of the cases, I would like to proceed with the issue number 1. Much obliged. Very verbatim of the issue number 1 states whether monetization of Nisha Batani without disclosure of her artificial origin undermine public trust in digital commerce. To highlight this, I would like to divide my arguments into 3 particular limbs. First of all, I would like to describe what does digital commerce means and what causes the public trust erosion in digital commerce. To describe it, I would like to mention that the public trust in digital commerce will invoke when the actual transaction exchange has become fraudulent, product quality, payment exchange, scrutiny, delivery, accurate description of the goods has been misrepresented. Here, I would like to invoke the attention of my lords on page number 37 of our submitted compendium, which states section 2, subsection 28 of the Consumer Protection Act. I would like to read it for the bench that misleading advertisement in relation to any product or service means an advertisement which first falsely describes such product or service. Adhering to this principle, I would like to submit nowhere my client Balvinder has misrepresented his persona as Nisha Batani. Secondly, gives a false guarantee to or is likely to mislead the consumers. Here, the misleading of the consumer has not also happened because the cheek blush cream for which my learned friends were coming to Nisha Batani to get promoted were never misrepresented or my client has never compromised with the advertisement itself. Thirdly, conveys an expression or implied representation which, if made by the manufacturer or seller or service provided thereof, would constitute an unfair trade practice, thereby following deliberately conceals important information. Though I would like to address the concealment issue highlighted by my learned friends in my further limbs, I would like to mention that the CCPA's own guidelines, 2022, my lords, if my lords find it's kind enough to turn page number 57 of our submitted compendium, rule number 6 and rule number 7, public trust erosion in digital commerce. Your lordship, I would like to draw the attention of my lords into the Moot proposition, where it suggests.
Just a second, counsel. You mentioned CCPA's 2022 guidelines just now, if I'm not mistaken, right?
Yes, your lordship.
So you spoke about guidelines 5 and 6 or 6 and 7?
6 and 7, your lordship.
And are you familiar with the guideline 13 of the of those same guidelines?
If my lordship can give me 30 seconds, I will be turning to the page number and would like to address it subsequently by my next arguments.
Okay.
Okay.
Proceed.
Are 30 seconds permitted? Much obliged. May I seek a clarification from my researcher?
Yes.
Much obliged. The council will take note on this and will be dealing, will be merging it with the further submission. May I?
Yes.
The limbs I was dealing with, the record does not establish an erosion to the public trust. Adhering strictly to the Moot proposition provided, I would like to ask my learned friends, where is the evidence of the loss of the trust? There is no evidence of regulatory intervention. There is no such evidence of a measurable decline in consumer confidence. Because the clarification 4 submits that are particularly significant here. Your lordship, those previous collaborations were successfully completed which were performed with my client Balvinder. and it also remained undisputed. Clarification 4 explicitly mentioned that, and were not subject to complaints on any grounds.
But did you not have a legal duty or a
Yes,
regulatory duty to be transparent?
Your Lordship, I will be dealing in the issue number 1 and the third limbs of my arguments.
All right.
Duty to disclose part. May I with this?
Yes, please.
Yes, Your Lordship. Her images were incorporated, rather, if they are alleging us for creating erosion in the public trust, they should come with clear hands with themselves. What they did, they exploited our images. My learned friend has repeatedly mentioned in their oral arguments that their prime intention was to get benefit from Nisha Batani. They benefited from for getting the benefit. They not only exploited our images, but also even after getting the exposure that Nisha Batani, as per their contention, they were not aware that Nisha Batani was an AI human being. Even after getting Nisha Batani's AI disclosure, they were never stopped with exploiting our clients' images. Furthermore, I would like to proceed. Even though few digital literacy concerns my client, my learned friends were not concerned enough that it was easily detectable from the it was easily detectable from the Moot proposition and the pictogram post itself that Nisha Batani was an AI generated images, because in the Moot propositions, page number 1, I would like to draw attention of my lords. Here it has been mentioned in paragraph number 2, in recent years, a significant shift has been observed in the nature of content circulated on platform with AI-generated images, digital avatars increasingly being used as primary tools for audience engagement. Such content allows creators to gain massive viewership and monetization opportunities without revealing their real identity, my lords. Here again, coming with the page number 2 of the propositions, para number 1 suggests that his growth attracted, his means my client's Balvinder's growth, attracted attention from both local and national brands seeking to leverage the popularity of AI-generated content to reach younger, digitally native audiences. Here, my lords, from these particular mentions, it is very clear, it was very much discoverable from the current advanced scenario of Indersilona that not only the union budget of 2026 was emerging to develop with the regulatory advancement, as we all know the updating construction doctrine highlighted in S.J. Chaudhary case, but also while Bhaskara Singh, being a CMO of a company named Cosmopolis Essential, were emerging to contact with a mid-time macro influence, and that is my client, he must have been this necessary awareness that it is an AI generated. Because again, I would like to...
just one...
yes, your lordship.
Just one question. Whether the appellant should have exercised ordinary diligence or due diligence to figure out the nature of your Balvinder's created digital persona is a separate point altogether. My question to you is that are you contending that a digital avatar has a legal personality? Is that part of your contention?
No, my lords, my submission is not adhering whether the digital persona.
In that case, how exactly is something which is not a legal personality have an agent or a manager, which is clear from the communication that you have your client actually has met to the appellant? Can you explain that?
Your lordship, much obliged to your lordship. With the contentions of your lordship, I would like to highlight that it was clearly mentioned in the proposition that actually I was emphasizing to this point very much. Page number. There is a Instagram chat box, pictogram chat box screenshot in the propositions mentions that Bhaskara Singh had been scrutinizing Nisha's profile through a very particular time. And also there in the propositions, page number 8 of the proposition, there is a symbol and liked by Vashkara Singh and others, and my contention is that it was easily detectable because in the chat
it was easily detectable is fine, but you allowed them to work with you thinking Nisha is a real life person, and Nisha was used as a real life person by them, thinking that she will be their brand ambassador and advertise or use her for advertisement. So now when they realize that it was not a real life person and she was an image, is there no breach?
Your Ladyship,
Aren't they entitled to a legal remedy?
Your Ladyship, furthermore, I would like to highlight this contention that nowhere my client has mentioned that Nisha is a real human person. Nowhere in the proposition, nowhere in the evidence.
Which is what I'm asking you. Are you saying that a digital avatar has a legal personality? Because otherwise, how exactly can a digital avatar have a manager?
Because it's the very facts of the proposition, because we have there are certain my lordship, there are certain kinds of accounts in pictogram profile which are only gains viewership just because it's an AI account, and as we
No, are you suggesting that these communications which are mentioned in this pictogram chat box have not been made by your client?
No, my lordship, my contention is that there is no such statutory obligation on that time. During the contract was made, there was no statutory obligation to speak or to disclose that, because as I have already submitted, the material fact was not that the contract was, whether the contract was between the non-human persona or between a human avatar, human persona.
Counsel, when a contract is entered into, the discussions pre-contract, while they may or may not be binding separately, that certainly goes on to show the state, whether the consensus ad idem has been achieved. But in any case, proceed.
1 minute. Madam, come to page 13, the WhatsApp references.
Yes, your lordship.
And the next page, the email. What would a man of ordinary prudence think? This is a deceptive representation or a correct representation?
In the chat box, there is a line mentioned that I have been following your work and genuinely admire your presence and authenticity in the beauty space. If your lordship please go through the verbatim, the authenticity in the beauty space, it means that product packaging, not the disclosure. Furthermore, continuing to the email, Balvinder, there is an email is signed by the Balvinder. So, though
that must be read along with the WhatsApp where a manager word has been referred to.
Pardon, your lordship?
That must be read along with the word manager which has been referred to in the WhatsApp messages. You come to the previous page, page 13, WhatsApp, artificial person making a human person a manager.
Yes, your lordship, here it is the Nisha's profile, because Balvinder was already aware, as he has previously dealt with the other brands collaborations. He was very much aware that there is no such necessity.
No, counsel, did your client write these responses or not? That's a fairly straightforward question. In the pictogram, as per your contention, did your client write it or not?
As the Moot proposition is silent
Moot,
about
I'm asking your position with regard to your client. The Moot proposition does not mention whether your client has written it or not.
Actually, this will be dealing by my co-counsel subsequently in issue number 3 only. So.
But counsel, this is a question of fact I'm asking you. You should have a common position with your co-counsel about what question of fact is. Had they been a law, that can differ. But anyhow, please proceed.
And the email IDs of Nisha's?
Your lordship, in the email IDs.
For collab mail at nisha96@gmail.com.
Yes, your lordship, because it was the Balvinder who has created Nisha, and he was managing Nisha's profile exclusively. So email ID can be, a person can have an email ID of different name.
Absolutely, counsel. But you just admitted the fact that it was Balvinder who was managing Nisha's profile. That
Yes,
includes
yes, Your Lordship.
that includes the pictogram profile, and as a result
Your
of that,
Lordship.
whatever communication has been made will have to be made by Balvinder. So here, Balvinder is claiming to be a manager of a digital avatar. Your client, that is. Yes. Please go ahead.
The council would like to proceed with the issue number 2 if the bench permits. With the bench permission, the council would like to submit a general illustrative thing which I will be arguing. It's just it's not an evidence, not regarding to the proposition. It's just an illustrative thing I would like to orate. So, if it's permitted. With the issue number 2, which is dealing with whether my client is entitled to get the copyright, I will like to submit, yes, absolutely, my client is entitled to get the copyright. Here, I will be dividing my arguments again into the 3 limbs. I will establish whether my counsel is, how much time is left? Okay. So here in the submissions, we have submitted 2 similar kind of prompts we have given to the ChatGen AI. So two similar type of prompts are generating different types of outputs. Even taking into records the contentions of my learned friends that as they are claiming it doesn't invoke the modicum of creativity, I would like to highlight the consistent labor and effort made by my client through the 2197 post is not a matter we should neglect here. As held by Stun Book Company versus DB Modak, they negated the doctrine of certain law and highlighted modicum of creativity, and also highlighted that it includes such as creating original hand notes, inserting internal paragraphs, numbering schemes, formatting text into such textual paragraphs, and adding contextual tags like conquering and dissenting. Here my contention is that my counsel has, with patience, has given the proof of his exclusive modicum of creativity, and he pursued it. How, Your Lordship? I will like to address. Suppose, like we have submitted to this annexure, that my counsel, maybe throughout making this 197 post, he has given multiple prompts. Even after giving the same prompts, the image cannot be. It is not such mandatory lines that image will be generated to the whatever my client is asking for, like the texture, the explicitity, the face cuts, whatever my client is requiring for, the required result will not appear even after giving similar prompt for multiple times, Your Honor. Therefore, it is the necessary. It is the digital literacy. Therefore, I would like to highlight that even a normal human being, a prompt engineer, is not needed for generating, for getting a work and get it entitled by the copyright. Even an ordinary person can do it. But my contention is that it needs an exclusive artistic work, because just as a painter can use a brush as a tool, but still the painting get copyrighted because the brush is here working. If we take into regards, the AI is working just as a brush and painter is my client Balvinder. Even if then the creation, Nisha Batani is entitled to get the copyright, because as per the analogy I have made for even the painting and the photographs, the cameramans and the painter are entitled to get the copyright, not the brushes and the cameras, Your Lordship. Furthermore, I would may I have just 1 minute? Yes. Furthermore, I would like to mention page number 25 of the compendium, section 2C and 13 of the Copyright Act. The relevant work constitutes artistic work, and the copyright protection depends upon originality rather than some requirement of inventive genius. Furthermore, I would like to highlight Here my client, just as in the case of Nova Productions, has not pressed a button and generated a certain image. Here he input his artistic skills, he invested, he created her facial identity, her body structure. He independently formulated the aesthetic strategy, Your Lordship. He didn't, it's not the AI to decide to output would ultimately publish. It is the author himself. Furthermore, going with the phased publication case, which highlights the garden of variety taste, I would like to highlight my client Balvinder is different from his. Here, not merely he is exercised this garden of variety, but also he has given the prompt expressly with his artistic skill and measure. Can I just have a 30 seconds to wrap up my... Okay, so my next and final contention would be the ownership follows the authorship, Your Lordship. Once respondent is recognized as author, Section 17 of the Copyright Act provides the starting point of the ownership. The respondent conceived and developed Nisha Batani independently for approximately 2 years before the Cosmopolis collaborations. Furthermore, page number 202 of our compendium submission, we have mentioned a case of Zaira of the Dawn, which highlights the representation that the selection and arrangement of the images in the work was done entirely. That's all on behalf of Council Number 1. Much obliged.
Just one last question for you,
Yes, Your
Council.
Lordship.
Are you aware of the practice of your jurisdiction's copyright office in granting copyright with regard to AI-assisted or AI-generated work?
Yes, Your Lordship. Should I interpret it like which jurisdictions we are claiming this?
The jurisdiction that you are arguing at.
Where would you require Nisha to get a copyright for Nisha? Authority, tribunal, or which? Where would you have gone to?
We have first went to the district court. Thereafter, an appeal has been made.
In the copyright office of the country where within which the jurisdiction this court lies, are you aware of the practice of the copyright office in giving copyright to AI-assisted or AI-generated work? Has there been any instance?
May I have just 10 seconds?
Sure.
Your Lordship, the copyright already subsists. According to Section 13, there is no mandatory obligations has been made that it has to be registered. It is subsists.
That's not what the question is asking. It's a general question. Do you know to which authority one has to approach to get a copyright for a AI-generated image, or that is what is the question? Is that the question?
It's to the Copyright Office.
So does your copyright office in that jurisdiction have in the past granted or rejected copyright for any AI-assisted or AI-generated work? Or is this, are you trying to make a point that this should be the first of its kind?
Yes, Your Lordship.
Which part of my question did you say yes to?
Your Lordship, as you have asked that...
Go ahead. Which part?
Don't get nervous. You tell
that's
us.
Fine. It's a fairly good faith question. You
tell
tell me.
us, yes,
Are
yes.
you aware of any such scenario where copyright office has given this kind of copyright, or is it the first time you are arguing that AI-assisted work should be given copyright?
There is an UK case, the Thaler versus...
Okay, that's all.
All right.
Thank you, Counsel.
You have won the case in the trial court. You are just defending.
Yes, Your Lordship.
So you must be. You have everything with
In
you
your
right
favor.
now. Take your seat.
Please.
All right. Next speaker. Yes. Yes, of course.
ট্যাক্স আর এদের প্লেসমেন্ট অ্যাপ্লিকেশন কোনো সেন্স নেই একদম। আর মোটের প্রপোজিশনটা প্রথমে যে পয়েন্টস যেটা হবে রেসপন্ডেন্ট আর অ্যাপিলেন্টে কখনো এক পয়েন্ট হতে পারে। হ্যাঁ, কিন্তু এখানে যে কাউন্সিল আর্গু করবে না তার তো পয়েন্ট আলাদা হবে।
Yes.
Your Lordship, I am the co-counsel appearing on behalf of the respondent, and I would like to address the bench collectively as your Lordship and individually as the leadership and your Lordship. Your Lordship, before coming to my arguments, that is the third and the fourth issue on behalf of the respondents, Your Lordship, there are few facts that were in this honorable court that were this court was misguided by few facts. The first is that, Your Lordship, my learned friends appearing on behalf of the appellants, they mentioned that the council is a virtual influencer. Your Lordship, in this case, the council is Balvinder Mukherjee, who is an actual person, as per the Moot proposition. And subsequently, Your Lordship, my learned co-counsel has mentioned that the moment the appellants discovered about this AI origin or the AI persona, they immediately, I quote, revoked the contract. But Your Lordship, as per the Moot court proposition, there is no explicit revocation of the contract that has been made. A payment as per the contractual obligation, that's what we are contending, has been withheld. That's the fact that I wanted to put on the records before this honorable court, Your Lordship. Now, Your Lordship, coming to my third issue.
Did you have a counterclaim in the suit?
Yes, Your Lordship.
Did you have a counterclaim in the suit?
No, Your Lordship, what I intended to do is that there were few facts before this honorable court that are not inconsistent with the Moot court proposition. So that is what I tried to shed some light upon, that what actually are the facts. That was my intention, Your Lordship.
Okay.
Much obliged, Your Lordship. Your Lordship, the third issue actually deals with whether there was a lack of transparency regarding the artificial origin of Nisha Batani and does not render the contract unenforceable, Your Lordship. If my lords are kind enough to turn to page number 23 of our submission, Your Lordship, we have submitted that the alleged lack of transparency.
Yes.
Yes. Your Lordship, the alleged lack of transparency does not affect either enforceability of the contract or the respondent's entitlement to payment. Your Lordship, we are going to put before our argument to two limbs. The first is the enforcement of section 64. Since this contract was actually restricted to the delivery of two promotional posts in return of exchange, the authenticity of the post was never the object of this contract, Your Lordship. Thus, based on that premise, we will be placing before this honorable court our argument for contractual obligation, Your Lordship. The first is that, Your Lordship, we are humbly submitting that the respondents never concealed the identity of the contracting party. Cosmopolis Essential negotiated with Balvinder Mukherjee as per the email conversations prior to when the contract was entered, Your Lordship, as per the Moot proposition. In his own name, and Your Lordship, this contract with Balvinder Mukherjee was named in Balvinder Mukherjee's name. The products were delivered to Balvinder Mukherjee's residential address, as well as the payment, the first payment of 1 lakh rupees was transferred to Balvinder Mukherjee's personal bank account as per the Moot proposition suggests. Thus, Your Lordship, throughout the transaction, the appellants dealt with a real, identifiable and legally competent natural person capable to contract under section 10 of the Indian Contract Act. Thus, Your Lordship, we are suggesting that this contract is valid and the contractual obligation does lie, Your Lordship. Your Lordship, pertaining to the contract, the agreement contained no clause requiring the creator of the persona to be a real human being, as per the agreement. Subsequently, Your Lordship, if we refer to the explanation of section 17, which expressly provides that mere silence does not amount to fraud unless there is a duty to disclose the silence, which itself is equivalent to speech. Now, Your Lordship, argument that was what we are contending over here. If my lords are kind enough to turn to page number 24 of our submission, on paragraph number 30, my lords will find that we have submitted that the relationship between the parties were purely commercial, negotiated at arm's length between a brand and an influencer's manager, as per the parties that have entered into the contract. Subsequently, Lordship, no fiduciary duty, nor did the respondent make any express or implied representation that Nisha Batani was a real person. Subsequently, the profile merely contained the bio wandering in my mind, together with the collaboration email directing towards the business inquiries. Subsequently, Lordship, this was, as per the Moot court proposition, this was a common practice in the industry. Your Lordship, before coming to the cases, I would like to place also one more fact, that in the present case, the character and the substance of the transaction remained unchanged. Subsequently, the respondents undertook to create and publish promotional social media content for Cosmopolis Essential, and our duty as per the contract, Your Lordship, was fulfilled, and thus payment was due the moment we delivered the promotional post to the appellates, Your Lordship. In the object of the contract did not dealt with whether the promotional post has to include an authentic person or an AI creator, Your Lordship. As per the Moot Court proposition, Your Lordship, our client, that is the respondent Balvinder Mukherjee, is a AI creator, is a mid-time creator who creates who has a page that is Nisha Batani, Your Lordship, and has been running for around 2 years, which has seen exponential results, Your Lordship. That is the first premise why the appellants themselves approached our client, Your Lordship. Now, Your Lordship, before coming to my actual, the second limb, yes, Your Lordship.
And in page 24 of your proposition, of your memo,
Yes, Your Lordship.
you have, in paragraph 29, you have cited this case of Sri Krishan versus Kurukshetra University.
Yes, Your Lordship.
What were the facts of this case, counsel?
Your Lordship, basically, this case dealt with, was actually the question of law. In this case was, yes, Your Lordship.
What were the facts of
Yes,
this case, counsel?
Your Lordship, this case dealt with whether the fiduciary relationship between two parties in a contract does have a statutory obligation or not, Your Lordship, as per my knowledge.
Does your compendium or any other case actually has this case? Can you tell me a little bit about anything about the facts of this case, counsel?
Your Lordship, can I just refer to the company? Your Lordship, I'll be coming back to that. Once we find the case, I'll be coming back to that. Once we find the case in our compendium.
Problem is, counsel, Sri Krishan, I have that case in front of me.
Yes, Your Lordship.
Sri Krishan versus Kurukshetra University is topic had absolutely nothing to do with what you have cited here. Neither the facts nor the law, counsel.
Much obvious, Your Lordship. My co-counsel are searching for that. If I may come to the court afterwards. Your Lordship, in the third issue, what actually, I take that point, Your Lordship, and the council takes that point, Your Lordship. But coming to the third issue, Your Lordship, that is the contractual obligation. Why does the contractual obligation lies? What we are trying to establish that if we refer to the Moot Court proposition, as per the email conversation, this contract was entered between the respondent counsel, that is Balvinder Mukherjee, and the appellants, Your Lordship. In this contract, the object of the contract was that the appellant, that the respondent will make some promotional post in exchange of a payment, Your Lordship. Now, after receiving the post, after receiving the material, Your Lordship, the appellant have withdrawn from the payment, Your Lordship. Now, my Lord, I would like to refer to section 64 of the Indian Contract Act, which specifically deals with a scenario like this. Your Lordship, section 64 deals with consequences of rescission of a voidable contract. That means that after one party has received the benefit from a contract, they cannot simply resent the payment or the object that their duty had to fulfill just because the contract they have discovered is to be voidable, Your Lordship. That is subsequently the further part. But what our contention over here is for contractual obligation is that the appellant counsel was obliged to pay the respondent counsel for the post that they have received, as per the facts of the case and as per section 64 of the Indian Contract Act, Your Lordship. Subsequently, Lordship, a very pertinent case. Lordship, I've got the case of Sri Krishnan and the Kurukshetra University. And Your Lordship, in that, what we tried to refer, the exact, the reason why we cited, is that this case has observed that it is not found that if a person on whom contract is so committed can discover the truth by due diligence, Your Lordship. So the reason why we cited this case is that we were trying to negate the part that actually, in my further argument, in copyright infringement, I will establish, Your Lordship, that there was a part of due diligence that was satisfied on part of the appellant's, Your Lordship. I will come to that.
So again, repeat what you have said regarding Kolkata University.
Yes, Your Lordship. So this judgment, the judgment observed that regarding fraud.
Which paragraph?
Your Lordship, Your Lordship, the third paragraph.
Facts of the case deal with allowing students to sit in examination or not. How is it applicable to this case?
Check.
Council, just to make a point here, that while a digital avatar AI made digital avatar may be a good substitute for a real life influencer insofar as marketing and advertisement are concerned, AI based research is rarely a proper substitute for original research.
The Council takes a note for that, Your Lordship, and the Council takes a note for that, Your Lordship. Your Lordship, but coming back to contractual obligation, I hope that the points are noted that our basic limb of argument is based on section 64, that this contract does not deal with the authenticity of the person. The object of the contract was, in exchange for the promotional post from the respondent council, the payment was due, which as per the current scenario, the obligation has not been fulfilled, Your Lordship. Subsequently, Your Lordship, one more fact that needs to be presented before this honorable court is that Vaskara Singh's own suspicion, only after reading the comments beneath Nisha Batani's public post, where the account has been already described in the comment section as digital avatar, Your Lordship. Now, the comments were publicly available and discoverable through ordinary diligence, because if my lords will refer to the Moot proposition, before entering into the contract, Vaskara Singh was already following Nisha Batani's page. She was already engaging with the content of Nisha Batani. And subsequently, Your Lordship, what we are trying to refer is my learned friends appearing on the appellant side. They refer to the WhatsApp, the Instagram chat, the chat box, Your Lordship. If my lords will refer to the chat box, first chat, the last line, Vaskara Singh herself admits that I've been following your work and genuinely admire your presence and authenticity in the beauty space, Your Lordship. What can be inferred from this is that there was an independent analysis from the part of appellants before entering into the contract, which, according to us, satisfies the due diligence part. Subsequently, Your Lordship, what we are trying to infer for the last limb of my argument before moving to the fourth issue, Your Lordship, in the contractual obligation, is that, again, authenticity of the person is a separate case altogether, Your Lordship. But here, as per the facts of this case, and my learned counsel appearing on behalf of the appellants also cited a wrong fact that Cosmopolis Essential is a small beauty brand. As per the Moot Court proposition, after this collaboration, Cosmopolis Essential became one of the leading brands in the beauty space after this brand collaboration, Your Lordship. As per the Moot Court proposition, my lords will find it on page number 3, the first paragraph, fourth line of the Moot Court proposition. Page number 3, first paragraph, fourth line, Your Lordship. This move caused a meteoric rise in sales, positioning Cosmopolis Essential as a leading cosmetic brand among Gen Z in Barcelona, Your Lordship, in the entire country. That is our assertion before the... is the time up? 3 minutes. So subsequently, the fourth issue about copyright infringement, there is a very pertinent part in the compendium, Your Lordship. If my lords are kind enough to turn to page number 88 of our compendium, my lords will find a term of use, the terms and condition of the platform on which this image was generated. As per the terms and condition of this platform, Your Lordship, the person who enters the prompt is the person who has the accountability to the content. I will come to that, Your Lordship. I hope my co-counsel has established that from a single prompt, different kind of results can be generated in on the AI platform on which we are dealing with today before this honorable court, Your Lordship. If my lords will refer to the terms and condition, the highlighted portion on page number 88, the terms and use of OpenAI platform categorically mentions that a person who is inputting the prompt is the person who will be responsible for the output and will be accountable and will have the rights to the content that is generated from that AI platform. It's on page number 88 of our compendium. Subsequently, Your Lordship, the platform through which this entire case or this entire digital persona is being necessitated, that entire platform itself is giving the rights to the respondent counsel, that is Balvinder, Your Lordship. I hope my lords have got the terms of use. So subsequently, Your Lordship, there is no question of authenticity over here. That is copyright. Thus, on the fourth issue, Your Lordship, we are contending that there was a copyright infringement based upon this premise. Since Balvinder had the copyright rights, now, Your Lordship, as per section 14C of the Copyright Act 1957, it confers upon the owner of the artistic work the exclusive right, inter alia, to reproduce the work in any material form, to communicate it to the public and make an adaptation therefore. Your Lordship, the contention that came from the learned appellant counsel is that there was an adaptation. But Your Lordship, we have a contention to that as well. Your Lordship, let's assume as per section 30, there needs to be a license. Whenever two parties enter into a contract, we can assume that in this contract, Balwinder did give license to the appellant counsel for the posts that he have created for them, the 3 promotional posts. That I am creating these 3 posts, you can use it on your social media platform or as per your advertisement strategy, Your Lordship. But Your Lordship, what we are trying to infer over here is that as per this contract, it was a limited license, Your Lordship. And that license did not extend to adapting or reproducing our existing pictures, Your Lordship.
But they said that we are delighted to associate with Nisha. And in reply you said we accept all your I accept all your terms and conditions and treat it as a formal contract. What else was they supposed to do?
Your Lordship, what I am trying to infer, my Ladyship, is that this contract dealt with few promotional posts. So based on this statement, what my Ladyship has correctly pointed out, Your Ladyship, this statement can be read under the light of the object of this contract. That this contract only dealt with few promotional posts. But Your Lordship, we are contending the 4th issue deals with that there was a copyright infringement of what happened after this contract was done. If I may conclude in a few minutes, Your Lordship. So, Lordship, what we are inferring over here before my Ladyship and before my Lords is that this entire copyright infringement, the question, is arising after this contract has been, the payment has been restricted. As my Ladyship has addressed, that actually from the reproduction on the brands, the appellants have profited from that reproduction. And Your Ladyship and Lordship, during that reproduction or adaptation of our work, our explicit consent was not present. Now, Your Ladyship, addressing to the fact of adaptation or reproduction, the impugned image, even if for hypothetically we characterize it as adaptation, just an adaptation work of our original work, Your Ladyship, the exclusive right to make any adaptation of an artistic work also rests only with the copyright owner under section 14C subclause 3 of the Copyright Act. And it was subsequently, Ladyship, if you are now considering with the reproduction part in the copyright infringement, we are further submitting that the infringement extends beyond product packaging. The evidence demonstrates that the photographs were displayed on Cosmopolis retail stores and outdoor hoardings, which are visually distant from the original viral image, Your Ladyship, and the recoloring package. But, Your Ladyship, the appellants, my Lords, the appellants therefore commercially exploited multiple unauthorized depictions of Nisha Bhatani persona across different advertising medias, whether reproduced from the respondent's existing work constituting reproduction or independently generated by the appellants as adaptation incorporating their original expressive element. Because as per the facts, the facial structure and the body and the physical structure of Nisha Bhatani was meticulously designed by Balwinder, Your Ladyship, thus invoking the expression part of copyright jurisprudence, Your Ladyship. That expressive part of our work was reproduced and readapted without our explicit consent, which was also outside the original contract that only dealt with promotional post. 3 promotional posts, not anything beyond that, Your Ladyship. And that too in exchange of payment. First, the payment was withheld after even if when we dealt with our duty, Ladyship, and subsequently above that, our work was reproduced without our explicit consent, Your Ladyship. That is why we are dealing with the copyright infringement comes into place. And as per terms of use as well of the AI platform, the person who gives the prompt on our compendium 88, page 88, the person who gives the prompt is the one who is actually accountable for the output, Your Ladyship, and the content that the AI platform is felicitating, Your Ladyship. That is what we are trying to contend before this honorable court. And this was also with that, I would like to move to the prayer from the counsel of the respondent. Wherefore, Your Ladyship, wherefore, my Lords, in the light of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court that if it may please to be dismiss this present appeal filed by the appellants Vaskara Singh and Cosmopolis Essential and uphold the judgment and order dated 21st March 2026 passed by the District Court of Kolkata in its entirety declare that the AI generated image and reels comprising the Nisha Batani persona qualifies for copyright protection under Copyright Act 1957 and the terms of use of the AI.
Copyright protected.
Yes, Your Ladyship.
This spread that you have made now, that means it was not copyright protected.
Your Ladyship, we are appearing before this Honorable Court to reinstate that fact, Your Ladyship.
Declare
Yes, Your Ladyship.
that, what is your prayer?
Declare that the AI generated image and reels comprising the Nisha Batani persona qualify for copyright protection under. Your Ladyship, for that I presented before my lords the terms of use of the OpenAI platform. But since this Moot proposition is silent, whether the district court has recognized the copyright rights, that is why with the premise.
Has granted the prayer on the basis that there is a copyright protection, but your prayer in the appeal is that the declaration that it is a copyright protected, then it should be
Then, Ladyship, we would like to refrain that reinstate. If this Honorable Court may reinstate again that we do.
It is there, how will we reinstate?
The council takes the point, Your Ladyship. The council and declare that the alleged lack of transparency does not affect the enforceability of the agreement dated 24 to 25 January 2026 and direct the appellants to pay the outstanding contractual dues as per the contractual obligation for the second and the third post. Declare that the appellant's unauthorized use of the respondent's protected image on product packaging, in-store display, and outdoor hoardings constitute copyright infringement, and grant the respondents damage, account of profit, and or any restitutory compensation for the unjust enrichment derived by the appellants from the unauthorized commercial exploitation of the respondent's work, and pass any other order that this Honorable Court may deem fit and proper in the interest of justice, equity, and good conscience. That would be all from the Council of the Respondents' Ladyship, my lords.
Thank you.
Much obliged, my lords.
Whatever is comfortable for them, we are okay with anything. Just maintain the time for the rebuttal.
Council seeks permission for it. My lords, Council 1 will be speaking for 3 minutes for issue 1 and 2 rebuttals, and thereafter my co-learned counsel from the appellants, he will be speaking for next 3 minutes. Putting first thing first, there is a huge allegation on us that we misled the code within the facts, and we stated that what is a virtual influencer. The definition says virtual influencer are fictional computer generated people or avatars who have been realistic character features, and therefore we state that Nisha Batani is a virtual influencer. There is no misinterpretation of the factual circumstances. Secondly, they have stated that we became a brand. That's ex post factum, which means once we gained the collaboration with Nisha Batani, we became the bigger brand. The moment we entered, my learned friend, when he said we are a small company. Before it was ex ante. And after the brand, and therefore the paragraph number 1 of the Moot provision page number 3, which states that ex post, after the effect, we became a good company, that too among Gen Z, which is, we know that's a major population in the country, but not at all. Secondly, they said that we were easily detected as AI. How? Because the chat box itself says we were completely engaging again. Then also we are not able to detect it. And how we were able to detect the other AIs with respect to the AI label. Therefore, they are misleading this honorable court because they are saying that we were easily able to identify, but they are not telling us how we were easily able to identify, even though we have created due diligence on our part. Secondly, they are claiming copyright under 2 clause 6, 2 clause C. And 2 clause C means artistic work. And the council number 4, the 2, they says that we are seeking infringement under 2D. Those two are completely different things, my lords. You cannot incorporate all the two things, and therefore this brings me to the third point. They are mentioning that we are coming under Consumer Protection Act. No, we must have went to under section 34 of the Consumer Protection Act. We must have went to the District Consumer Commission for that redressal, or the consumer whosoever is having. We are not able to, we are not here from the consumer side. We are here for the appellate side, who is Bhaskara, Singh and Balvinder, and we are not consumers. The consumer guidelines are not applicable on them nor applicable on us as well. Therefore, this is the second counter. Thirdly, my lords, they are saying that there subsists a copyright. No. They must have went to the copyright office. They haven't not. bench very genuinely asked whether in this jurisdiction we had any single entity who got copyright in AI. There was only one case, which is Surya's AI and Ankit Bashin case. That too, that is not publicly available. And there also, as per the spicy IP and all these unrecognized sources, that was a co-author. And again that notification was withdrawn, and therefore that notification is still not available within the scope of this jurisdiction because it's not publicly available. Therefore, when we do not have any single case, and they are saying that the prompt which they have submitted as the annexure, what they have done is they have given a prompt. Whether they have submitted the prompt which they have disclosed, from which they have made Nisha Batani, no, my lords. I will just conclude with this. And again, yes, a principal-agent relationship herein does not exist under the scope of Indian Contract Act. Much appreciated.
Much obliged, Millards. Firstly, they have made certain mistakes. Like 3 posts were there. First was the reel, and the other 2 were the photographs. For the photographs, nothing happened. Like we also did not post the other 2 photographs. So the payment they are asking for 50,000 into 2. That actually that action has not happened. Secondly, the image that has been there in page number 13, where it is said that I have been following your work and genuinely admire your presence and authenticity. This word has been mentioned in your beauty space. The onus then becomes much greater for Balwinder to come out clean and so as to come out clean. So basically they have said that we came with the clean hand, but they did not, because they are saying that authenticity is mentioned, but they are still said that go contact my manager and do this and so on and so forth. Now I would like to we are saying that they do not own the copyright. They have also kind of agreed to it. Secondly, we are saying that the green Moot prop is silent on it, whether the green sari, we saying that we have generated it. Finally, my lords, I would like to submit with their best case versus our worst case, and still how we win. So they took you to section 17 of the Contract Act. Section 17 of the Contract Act, this is their best case, has an illustration. The illustration says A sells by auction to B a horse which A knows to be unsound. Now A says nothing about the horse's unsoundness. Here unsoundness is material fact, right? This is not fraud in A. So they have sold us, they didn't tell us about the material fact that this was an AI. But the problem herein lies is that this is an auction primarily. Here multiple parties will come to which we are not privy to. And in this case, we are dealing one-on-one with one-on-one with a particular party, both of us having business interests. So this is how, going by the great Mr. Ram Jethmalani's words, when you find nothing very substantial as this case, not really, it does not have that much of jurisprudence to rely upon except a few certain cases, we should find out illustrations. And I just proved how their best case does not stand in front of our worst case. Thank you, my lords. It was really a pleasure to argue in front of esteemed judges. Been many times at your court, ma'am, and your beloved, and yours. Thank you. Thanks a lot.
My lords, few contentions was made against what we have said, specifically what I presented before this honorable court. The first counsel appearing on behalf of the appellants, in his opening remarks, mentioned that the counsel in this case is a virtual influencer, lordship. We had a contention over there. The respondent counsel is Balwinder Mukherjee, as per the front page, as per the case. This case is between the appellants and Balwinder Mukherjee, who is the respondent counsel, not a virtual influencer, my lords. Subsequently,
counsel,
my lords,
why are you referring to your client as the counsel? This is the third or fourth time you have made that scenario. Balwinder is your client or the respondent, whatever you want to call it.
My lord. My client is an actual person named Balwinder Mukherjee, not a virtual influencer, which was contended by my learned friend, first counsel, appearing on behalf of the appellants. Now, my lords, the counsel of the appellants mentioned what we found out about the brand's scale. My lords, if my lords will refer to page number 2 paragraph number 2 of the Moot Court proposition, which is the only fact in the entire proposition which talks about the company, Cosmopolis Essential. In the verbatim, there is no word that is called small. Cosmopolis Essential is the cosmetic brand. And a case cannot be based upon assumptions that brand might be small, brand might be a micro brand, or might be a MNC. There is no mention of the scale of the brand in the Moot Court proposition as per paragraph number 2, page number 2 of the Moot Court proposition. That was the contention. Lordship, that was the contention that we made, that a wrong statement of fact was presented in my argument, and the learned appellant counsel is saying that that contention was wrong. So I just pointed out before this honorable court that from where I have derived that argument. Subsequently, the analogy of a best case. My lords, the analogy of a best case and the worst case is not based upon what we see justice as. Justice prevails when there are two cases, and it's the court that decides the equity, my lords. My lords, our case about copyright, the issue of copyright, the basis on which is standing is the term of use of the AI platform. We have submitted on page number 88 of our compendium that the term and condition of the AI platform categorically mentions that the person who is giving the prompt is the person who will be accountable for the content, and he will be responsible for the content. Subsequently, will have the rights of the content, your ladyship, my lords. Based upon that point and based upon that document of the AI platform that was felicitating this entire image creation, my lords, is based upon what we placed our case. Subsequently,
Counsel, the AI platform is not the authority to give the creator the copyright.
Yes, my
because that's at the max the AI platform can give you the rights.
My lords, my point was that the contention over here is the question of law over here is that who is the rightful owner, the platform or the person who is giving the prompt. That's what the third issue dealt with. That actual copyright lies with whom? The person who is giving the prompt or the AI platform who is generating the image. And as per the terms and condition, the person who is giving the prompt at the beginning is the one who has all the rights. What my lord is trying to infer is the subsequent part, that whether when we will apply in the copyright office, whether we will get the rights or not. That is the point of law. But here the platform that my client has used, the AI platform, it gives him the right to all the images that were generated. That is what the point of law we were trying to address, my lords. Subsequently, a contention was made that only one post was delivered. Only one among the 3 promotional posts, only one was delivered, to which the 1 lakh rupees payment was made. I would humbly urge my lords, and it is very important, to turn to page number 7, which shows the Instagram profile, pictogram profile of Nisha Batani. The second post, the last point, the second post and the third post, categorically we can see Cosmopolis Essentials product that are being highlighted in the hands of Nisha Batani. That is the contention we have. The evidence shows that all the 3 posts were delivered. The reel was delivered as per the Moot proposition, and as per the evidence, both the second post and the 4th post, we can see that Nisha Batani is having the cheek brush cream and I suppose the other product of Cosmopolis Essential in her hand, which is also posted on her profile, my lords. So how can this contention be made that only 1 out of 3 posts were delivered? That is our contention. And my lords, before ending, if I can wrap up the entire case before my lords for the order, the copyright infringement or even the contractual obligation in the contract, authenticity was never the question. 3 posts were delivered to the appellant counsel, the payment was due. The question of authenticity is a different point of law altogether, which is not the part of this case. And subsequently, my lords, the payment that was due were under section 64, that was due the moment we delivered it as part of our bargain in the contractual obligation. And copyright infringement, I hope I was able to clarify my lord's query that the AI platform, the term of use we are using is because the question of law, that whether we will be granted the AI law as per the Barcelona statute, is a different law altogether, my lords. But the platform at the first stage is granting us the right. That is what the term of use is trying to infer, my lords. That would be all from the counsel of the respondents. That would be all, my lords.
And excellent performance from both sides. And we actually had a lot of questions because we wanted to be a more interactive and participatory process, which like it is in court. So we didn't just want to hear you talk on your part, on your points, but we wanted to ask you questions so that we wanted to see how you can quickly think on your feet and interact with the court. So do not take us amiss and do not think that we wanted to make it difficult for you. We were just giving you a practice. Thank you very much. But both of you were excellent.
Hello.
The final rounds have come. All right, so the final rounds have come.
Hello.
Yes,
Hello.
the final
Hello,
rounds have
Chief.
come to an end. We will be moving on to our valedictory session. So I request our esteemed judges to please move down to a seminar hall where the valedictory session would take place. I request our esteemed Pro-Chancellor Sir, our Vice-Chancellor Sir and our Pro-Vice-Chancellor Academics Ma'am to please move down along with our faculty members. And I also request the participants to move down to the seminar hall for the valedictory session. Thank you.
Hello. Hello.
आगे participants then नहीं आगे participants then नहीं जाओ audience wait participants then नहीं जाओ आगे
I'll request all the audience to kindly wait for some times. Please be seated. I request all the audience to kindly wait for some times. Please be seated.